Well, good afternoon, everyone, and welcome to this Francis Taylor Building lunchtime webinar for our public law webinar series. And this one is an update on retained EU law. And for those who don't know me, I should introduce myself first of all. My name is Merrow. I'm a barrister here at FTB. I'm part of the Public Law Practice Group, and I will be chairing today. Now, I should say we're particularly grateful for you all joining. I can see the numbers are going up, so more people are joining as I introduce. We're particularly grateful for you joining on this beautifully sunny afternoon. And I was trying to think of some witty joke about sunshine and sunset clauses, but I can't. So I'll just say that I have no doubt that our two speakers today will be shining a light on this very important topic. And it's a topic where I think I'm not alone in saying I think it's one where many of us know we need to know about it, know there's quite a lot to know about it, but if, like me, you haven't yet had the chance in practice to actually deal with it directly, then the hope is, at the end of this webinar, you should know everything you need to know about where things currently stand. So we're going to look at the Retained EU Law Act. We're going to have a potted history of the legislation, where we've got to at this point, and also look at the case law, and there has been some case law on it already. So that's what we're going to cover. Now, no doubt many of you will be well versed in webinars and the procedure. We would very much welcome and invite any questions or comments as we go. Please just pop them into the chat Q&A function box, and we will try to answer as many as we can. We will be stopping promptly at 2. So if we can't answer any questions, we will then try and see if we can get back to people if we can afterwards. If you want to, do also feel that you can email Deirdre or myself with further questions if we can't get to you. But hopefully we'll cover some of the questions. Copies, I believe, copies of the PowerPoint will be, as usual, circulated as well. So don't feel you have to take all the notes down as we go. And we're also recording this webinar. So if you miss a few minutes for a cup of tea, you can always go back and watch the recording later. Before I forget, the next public law webinar is on judicial review, costs and procedure. It's an update on cost and procedure of judicial review. It's taking place on the 4th of June at the same time, 1 to 2 p.m. The chair will be Stephanie, and our speakers will be Armin and Michael from our chambers, Michael Feeney, I should say. We've got a number of Michaels. So that's the next public law webinar in the books. And then I believe there's a whole, that's the last in this series, but I believe there's a whole, another series in preparation that's going to take place in the autumn. So I will introduce our two speakers for today. I'm going to introduce them both at the outset, and they are both two excellent juniors, rising stars of the bar next to me. They both act across Chambers' broad practice areas with particular interest in public law and judicial review. And if they will allow me to briefly embarrass them, Michael Rhimes is to my right. And prior to coming to the bar, he worked as a law clerk to the British judge at the CJEU in Luxembourg. So he is excellently placed to speak to us here today on the dynamics of EU law. And we're also lucky to get him because he's got a very busy practice, as he's currently instructed on a 12-week planning inquiry. It's the headline hissing planning inquiry. He's acting on behalf of the LPA. It's the one into the Highstead Park development, which has been called in by the Secretary of State. So we're lucky to get him, and he's expertly placed to tell us all we need to know. He'll be dealing with the potted history of the Act and its latest position of the legislation. And then Esther will be taking us through the case law. And Esther, again, I will try and embarrass her too. She's ranked as a leading junior in Legal 500 and planning law. And she too is expertly positioned on this topic because she specifically, among other things, she has specifically advised on the effect of the Retained EU Law Act in the context of environmental information regulations. And she's also quite an expert on that topic, generally, I should add as well. You may also know her in terms of public law from the famous Darwell and Dartmoor Supreme Court case, where she acts on the team for the Open Spaces Society, and that was dealing obviously with public rights of access. And again, very headline hitting. She's also the commissioning editor, one of the two commissioning editors of our environmental law blog, and I will always try and do a plug for our blog at every webinar I can. So with that all being covered, I will now, and I think embarrassed enough, I will now hand over to Michael to take us through.
Thank you very much, Merrow. So my part of the presentation will deal with the context and provide an overview of what I shall call the 2023 Act. It will be in 4 parts. First, I want to give an overview of EU law before Brexit. In the second part, I'd like to look at EU law after Brexit in the light of the 2018 and 2020 Acts. In the third part, I'd like to focus on 6 features of the 2023 Act. And in the 4th part, time permitting, I'd like to take you through a recent report that arises out of the 2023 Act. So for the whistle-stop tour, it's fair to trace the origins of the EU to a period of institution building after the Second World War, including NATO and the Council of Europe. And in particular, the EU can be traced back to the 3rd point that you see on the slide, which is the European Coal and Steel Community in April 1951. And you might think that the European Coal and Steel Community Treaty is a fairly quaint sectoral treaty in the light of, the grand aspirations of NATO and the Council of Europe. But as you see from the 2nd point there, the idea was to bring together, in particular, France and Germany and other countries that wanted to join to unite their coal and steel production so that they could never again turn the machinery of war against each other. And in the end, 6 countries joined at the time, France and Germany, of course, Luxembourg, Belgium, the Netherlands and Italy. It was founded on a common market with common aims and common institutions, and most importantly, a judicial body to oversee it. Then the Treaty of Rome in 1957 sought to, as per the quote on the slide, lay the foundations for an ever closer union among the peoples of Europe, and took 3 bold steps forwards in that it was a more general form of integration with greater institutions and more developed institutions, and sought to foster broader rights and social policies among Europe. Then comes along the seminal case of Van Gent and Loos, in which private individuals sought to rely on Article 12 of the Treaty of Rome, which said essentially you can't increase imports within the EU, and the Attorney General the Advocate General in that case said, well, actually, no, Article 12 simply applies to member states. It doesn't give rise to individuals. And in a very significant judgment, the Court of Justice disagreed, and it famously held that independently of the legislation of member states, community law not only imposes obligation on individuals, but is intended to confer upon them rights which become part of their legal heritage. So this private individual could rely on treaty rights. Then in Costa and NL, the Court of Justice essentially confirmed the supremacy of EU law, in that EU law prevails, cannot be overridden by domestic legal provisions, and I've highlighted there, however framed, because the court then in Internationale Handelsgesellschaft in 1970 confirms that EU law also prevails above domestic constitutions, and the exchange with the German Bundesverfassungsgericht gave rise to interesting difficulties for constitutional scholars and non-German speakers alike. The UK then joins the EU on the 1st of January 1973 by referendum, and there was then a referendum on whether to remain part of the EU in 1975. And the 1972 Act essentially implements EU law in a way that is actually remarkably simple, despite the complexity of what was sought to be achieved. And I've put the relevant provision there, but it essentially says all such rights, and I'll skip over, are without further enactment to be given legal effect or used in the United Kingdom. So fast forwarding, we can essentially cover 5 broad species of EU law. First, there's obviously the treaties themselves, which prior to Brexit would have been the Treaty on the Functioning of the EU, the Treaty on European Union, and also the European Charter of Fundamental Rights and Freedoms. Second are directives, which are issued by the EU and then give member states a certain period to transpose them into domestic rules. Third, regulations, which are made by the EU and have immediate effect once they are passed and come without the need for transposition measures. Fourth, general principles. These are general principles that are defined by the Court of Justice of the European Union, such as the principle of non-discrimination and the principle of proportionality, and they essentially form part of the backdrop of EU law. They can give rise to enforceable rights and are also used when interpreting EU law more generally. And finally, it's also worth noting that as a result of EU law, a number of other principles apply. So, for example, there's an interpretive principle. When you're interpreting domestic law, you need to do so in a way that complies so far as possible with EU directives. And it also can give rise to causes of action, such as compensation for breaches of EU law. And I thought I'd just give a very brief case study of what EU law looked like before Brexit, and take chosen environmental law as an example. So if you take the EIA directive, the Court of Justice of the European Union would provide a consistent binding interpretation of that directive. That's point number one. The second point is that if, for example, the national transposition measures for the EIA directive say one thing, EU law prevails over that, and so in the event of a conflict, a court would have to apply the EU law definition and not the domestic rules. Third, there was also a duty to refer matters to the Court of Justice of the European Union, as was done by the House of Lords, for example, on an EIA case, the case of Barker and London Borough of Bromley. And finally, it's also worth mentioning that EU law could be policed by the Commission bringing infringement proceedings against a member state. So, for example, the UK was taken to the Court of Justice of the European Union in respect of its the way it had implemented wastewater treatment rules and air quality rules. I'll skip over the practical examples of EU law, but essentially it's worth noting that a lot of domestic law has been as a result of EU developments, and I give 3 examples there. So that's the end of the whistle-stop tour of the law prior to Brexit. We'll now have a look at Brexit in some more detail. And it's just worth refreshing the Brexit timeline. So obviously in June 2016, there was a referendum vote, very close, 52% overall voted to leave. In March 2017, there was a notification of our intention to leave the EU. In June 2018, there was the passage of the EU Withdrawal Act, which I will call the 2018 Act. We then had exit day initially scheduled for the 29th of March 2019, then pushed back to the 31st of January 2020. On the 1st of February 2020, there was an agreement signed between the EU and the UK, which I'll call the Withdrawal Agreement, and that itself had to be implemented, and that was implemented in the 2020 Act. Of course, in June 2023, that takes us to the Act that is the subject of this presentation. So to briefly go through the 2018 Act, essentially it sought to retain existing EU law, and there are a number of gateways and a number of things that were retained. So first, legislation passed to implement, for example, an EU directive known as EU-derived domestic legislation, that was retained. Also retained were EU regulations themselves, so the incorporation of what it refers to as direct EU legislation. And finally, it also saved EU rights, which are rights directly contained in the EU treaties. The 2018 Act ended the supremacy of EU law after exit day. And so, for example, as you see in point 3 on that slide, there could be no reference from domestic courts to the Court of Justice of the European Union after exit day. CJEU decisions were not binding after exit day, and as such, court could have regard to, but were not bound by those decisions. It also provided that retained EU law was to be interpreted in line with retained case law, but otherwise domestic courts were not bound by that case law, and there were powers to amend some retained EU law. I can go over the 2020 Act fairly briefly, but essentially this Act implemented the withdrawal agreement and changed the name of exit day to IP completion day. The 2 remaining points that are on the slides is just to bear in mind that the withdrawal agreement should not be overlooked, because the withdrawal agreement is in and of itself binding given the 2020 Act, and in some cases litigation may be started when the withdrawal agreement applies, and there may be transitional provisions that mean that the UK needs to be treated as if it were a member state. And so I give an example of that, the recent Supreme Court decision in Skykick Limited, which deals with IP rights. So in a nutshell, what did the 2018 Act do? It essentially took a snapshot of EU law as it stood prior to Brexit and retained that EU law. And it started a process of disentanglement, if you will. So it ended EU supremacy as of exit day, and also prevented references being made to the Court of Justice of the European Union, which of course was a hallmark of the constitutional relationship the UK enjoyed with the EU prior to that day. And why did it do so? Essentially to preserve legal continuity and certainty, and to avoid the effects of legal disruption if the UK were to crash out of the EU. So now we can go through 6 features of the 2023 Act, starting with the impetus for the Act. The Act was brought forward to Parliament as a bill in June 2022 under Boris Johnson's Conservative government. And the impetus for the 2023 Act can be seen on a number of levels, but essentially there may have been an impression that whilst formally the UK had left the EU, a lot of EU law was still frozen in time. Part of the impetus for leaving the EU in the first place were concerns over democratic accountability of the EU. And given that a lot of EU laws remained enforceable in the UK, there was a concern about the democratic legitimacy of those laws. And so finally, there was a desire to diverge from the EU to take advantages of economic opportunities. And it was put as follows in the Queen's speech in May 2022, where it was said, "My government will continue to seize the opportunities of the United Kingdom's departure from the European Union to support economic growth." And the overarching aim of the 2023 Act essentially breaks down into 2, as you can see in the explanatory notes. I mean, first, the 2023 Act sought to, and I quote, "facilitate the amendment, restatement or revocation and replacement of retained EU law." And it also sought to remove the special EU law features that are attached to that retained law. And so we can now turn to the 6 main features of the 2023 Act. The first and most important is sunsetting of retained EU law. And it should be emphasised at the beginning that the Act as passed was considerably watered down from the bill proposed in June 2022. Clause 1 of the bill would have essentially revoked all EU-derived subordinate legislation and retained EU legislation. So if you want, it would have been a retained EU law bonfire. Now, the position is that only the legislation that has been listed in Schedule 1, and it's about short of 600, is revoked at the end of 2023. And there's also been a change in language. Retained EU law is not called retained EU law anymore. It is now from the 1st of January 2024 called assimilated law. That's the first of the 6 features. The second feature is there were granted broad powers to ministers to revoke any secondary retained EU law, and the minister could then either not replace it at all or could replace it with an alternative. There are also some interesting powers to update EU law. So, for example, there's a power to update retained EU law on the grounds of progress in technological or scientific understanding, or to reduce regulatory burdens. As you might expect, the 2023 Act contemplates significant legal change, often in complex regulatory fields, and to assist members of the public and to provide a degree of accountability, the 2023 Act puts forward this concept of an EU law dashboard, which is an interactive dashboard of retained EU law. And I'll put a quote up there from the report we will consider in part 4 if time allows, and it explains that the assimilated law dashboard provides the public with information on how much legislation is derived from the EU and the actions the government has taken to either reform, revoke or retain it. So there's a duty on the Secretary of State to maintain and update the dashboard. And there's also, and you'll see in point 3 on the slide, a duty to publish and lay before Parliament a report on the revocation and reform of retained EU law every 6 months. So here is a screen grab from the dashboard, and to give a sense of scale, this dashboard says that it shows only the first 1,000 rows and 50 columns, but you can download the full dashboard should you so wish in Excel spreadsheet format. Quite a lot of information on the slide, and that's because there has been, as I indicate, a qualified abolition of the supremacy of EU law. And just to recap what we went over previously, if domestic law said X and EU law said Y, pre-Brexit, X was to be disapplied, so that Y applied. That's essentially the principle of EU supremacy. Before we go any further on this, I've put in bold in the second point there that this provision does not have retrospective effect. So whenever you're considering the operation of this provision, you need to consider when the underlying facts occur. But essentially, the provision can be summarised as follows. First, the supremacy of EU law is no longer part of domestic law, and as such, any retained EU legislation needs to be read and given effect in a way which is compatible with all domestic enactments and will be subject to domestic legislation. That essentially means that EU law no longer trumps, it's domestic law that trumps, and I call this the priority rule. There are important caveats to this, though, in that first, within the Act itself, there are certain parts of UK law that do not operate in accordance with the priority rule. One example of that is data protection. And the second is in point 3 on the slide, and that is there's a power to issue regulations designating certain parts of the law that will not operate in accordance with the priority rule. And if such regulations are provided, if a court finds there to be an incompatibility between domestic rules and retained EU law, then it needs to issue a declaration of incompatibility. So whilst at a high level, one might say that the supremacy of EU law has been abolished. That is technically correct, but I mean, as is often the case in this area, you do need to read the fine print. There's also been an abolition of the general principles of EU law, and some of the examples of general principles given in the explanatory memorandum are proportionality and protection of fundamental rights, and I will leave it to you, dear listeners, to decide whether these really are the boogeymen that we necessarily want to get rid of, but be that as it may. Under the 2018 Act, retained EU law needed to be interpreted in line with EU general principles. However, that is now no longer the case. You essentially interpret retained EU law using standard domestic principles of interpretation. It's explained in the explanatory memorandum at paragraph 104, and it says the changes made by section 4 of this Act mean that after the end of 2023, courts will no longer be bound, emphasis mine, to interpret assimilated law by such principles. But again, please do note that this provision does not have retrospective effect. Finally, and perhaps some of the most far-reaching implications of the 2023 Act are contained in section 6, and I've just put it in bold and underlined. It's important to note, unlike the other two provisions that I've referred to, which are in force, but they don't have retrospective effect, section 6 in its entirety is not currently in force. And of course, there is the question as to whether it ever will be brought into force, bearing in mind that there's been a change of government since the passing of the 2023 Act. But if one looks at the provisions as they, so if one looks at those provisions, if they are brought into force, it provides that obviously EU case law is no longer binding, and domestic court, in deciding whether to depart from retained EU law, must have regard to certain factors, and that includes the fact that the CJU is a foreign court, and judgments of foreign courts generally aren't binding in UK law. The court will also need to have regard to any change in circumstance, and whether following the CJU judgment would impede the slightly loaded term, but the quote-unquote proper development of domestic law. So clearly the impetus behind Section 6 is to lay the groundwork for courts to depart from CJEU case law where appropriate. It also makes provision for courts departing from its own retained domestic case law if it considers it right to do so. And this dovetails with some of the cases that my colleague Esther is going to discuss. But the upshot is that it makes it easier for a court to depart from its own case law. And finally, there's also a provision made for a sort of preliminary reference style provision in that a lower court can refer a question of whether to depart from retained case law up the judicial hierarchy. And so that takes us to the sixth and final feature of the 2023 Act that I wanted to go through. And so we can now discuss the report dated January 2025. You'll recall that as part of the dashboard provisions of the 2023 Act and to enhance accountability, the relevant minister needs to publish a report every 6 months and lay it before Parliament. And so this is the most recent report. So it explains that the dashboard initially chronicled about 2,500 pieces of retained EU law, namely 2,417. That has now escalated to just short of 7,000 provisions. So again, that gives a sense of the scale of this endeavour. Of those, about 2,400 have been revoked or reformed. And there's then a helpful table that says essentially what has been done with what is now called assimilated EU law. So according to table 1, I've just provided 2 statistics. The lion's share has actually been unchanged. So 64% of the provisions which are surveyed have actually not been changed at all. And about 22% have been repealed. So that's give or take a fifth. It then sets out the overall aim for the use of the powers under the 2023 Act, which says that the government is committed to creating a pro-business environment with a regulatory framework that supports innovation, economic growth, investment and high-quality jobs. And the third and final point that I draw your attention to is that, to put it bluntly, I mean, a lot of this work is highly nitty-gritty. And so even in the executive summary, for example, at paragraph 5, it gives examples of reforms to assimilated law, which we are told support government priorities. And it gives 2 examples, one of which relates to ionizing radiation medical devices. So a lot of this is perhaps despite the ambition of the 2023 Act, a lot of it manifests itself in some fairly fine-grained changes. That concludes my part of the presentation. Thank you very much for your attention, ladies and gentlemen, and I look forward to answering your questions at the end.
Brilliant. Thank you very much, Michael, for that whistle-stop tour, I think, of the history of EU law and where we've got to. And now I'm handing over to Esther.
Thank you, Merrow. So, as introduced, I'm going to be covering some of the principles arising from the case law on retained, or as we must now call it, assimilated EU law. And in particular, I'm going to cover first the rules and principles for departing from assimilated EU case law, as Michael indicated. Second, the status of post-Brexit CJEU case law and how the courts have approached that. Third, the legal status of EU rights which arose prior to Brexit, but which are going through the courts now after Brexit. And finally, some of the case law considering conforming interpretation, that mar-leasing duty that Michael mentioned after Rule 2023, which abolishes those principles. So first, turning to the case law on departure from assimilated EU case law. And there are 3 decisions of the Court of Appeal on this, all with the leading judgment of Lord Justice Arnold and all in the field of intellectual property law, which, as Michael mentioned, is one of the main areas which is really heavily governed by EU law. So the principles are now fairly well settled, as I'll go through with these three cases, although it is possible that a different Court of Appeal constitution that's not led by Lord Justice Arnold or the Supreme Court might take a different approach. But they're obviously very useful to be aware of if you do become involved in a case where either you or the other side might ask the Court of Appeal or the Supreme Court to depart from assimilated case law. So you really do need to be aware of the principles the Court of Appeal and the Supreme Court will take into account. So Warner Music and TuneIn was a case about whether TuneIn's links to internet radio streams on its website were a communication to the public and were in breach of copyright. And TuneIn asked the Court of Appeal, perhaps quite ambitiously, to depart from the entire body of EU case law on what a communication to the public was. But the Court of Appeal disagreed and found that this was a paradigm case in which there should be no departure from EU case law. And it gave a number of reasons for doing so, which are applicable in other contexts. So here there'd been no change in the domestic legislation which implemented EU law. There was no change in the international legislative framework, which included a number of copyright treaties that had been implemented by the EU law. Communication to the public was a difficult concept in which the CJU had unrivaled experience given the number of cases it had decided. And while there was academic commentary criticising the CJU's approach, it was not all one way, and there was some commentary in support of it. The parties made reference to case law outside the EU from the Commonwealth courts, for example, but that did not offer settled or consistent guidance on what a communication to the public should be. And in this case, returning to the drawing board and working out what a communication to the public meant, essentially from first principles, would cause considerable legal uncertainty. The Court of Appeal also considered the Supreme Court test for departing from its own jurisprudence, which is what the legislation applies, and emphasised that it should not refuse to follow an earlier decision of the Supreme Court or House of Lords merely because they would have decided the case differently. There needed to be something more for there to be a departure. And in particular, there was nothing in the Court of Justice's approach that either impeded or restricted the proper development of the law, nor was it leading to results which were unjust or contrary to public policy. The next case was a case between two very similarly named companies dealing with international cleaning equipment. And it was all about when the 5-year acquiescence period starts to run for trademark infringement. And the defendant in that case asked the court to depart from a finding of the Court of Justice in a case called Budvar about competing trademarks for the American and the European Budweiser. The Court of Justice found in that case that you need to be aware both of the registration of the later trademark and not just its use for that 5-year acquiescence period to run. And in that case, the Court of Appeal did agree to depart from the prior Court of Justice case law. And it gave these reasons for doing so. So the first was that there was no analysis of this issue whatsoever in the Advocate General's opinion or in the judgment. It was just a bold conclusion, something that might be familiar to those of you who read a lot of EU law. Their judgments can be stated pretty shortly. It was also an isolated decision. There wasn't a body of case law supporting this issue, such as in TuneIn. And in fact, Budvar, somewhat surprisingly, a Court of Justice case had not been followed by the General Court or the EU Intellectual Property Office in subsequent cases. Given those conflicting approaches, there wasn't any risk to legal certainty, as no well-advised operator would have followed the Budvar principle. They would have sought to consider acquiescence at an earlier stage. And the fact that there wasn't any academic criticism of this judgment was of little relevance, given it was such a narrow issue in a specialist field. There wasn't any academic commentary on it in general. And the court finally found that this Court of Justice judgment did restrict the proper development of the law. Interestingly, they also referred to two arguments of the claimant for departing, which they rejected. So again, useful to know if you're faced with this situation in the future. It wasn't relevant that this particular issue about acquiescence wasn't determinative in Budvar. So in our terms, we would say it's obiter dicta, because the Court of Justice doesn't follow strict rules of precedent which apply in domestic law. And also, again, it wasn't enough that a different reading was tenable and might seem preferable. There had to be something a bit more than that. So the third case is Thatcher's and Aldi, a decision from earlier this year. And that case was about whether Aldi had breached Thatcher's cloudy lemon cider trademark through a lookalike product. Now, in a presentation dealing with intellectual property cases, I didn't want to put the pictures of these two products on the slide, but I would say, have a look at them and see what you think. There is quite a strong similarity between the two, and they are actually pictured in the judgment. But Aldi asked the Court of Appeal to depart from the Court of Justice's finding in a case of L'Oréal and Belleur that consumer confusion or detriment to the trademark was unnecessary, finding an unfair advantage in trademark law, but that it was enough for a lookalike product to simply be riding on the coattails of the trademark product, even if there wasn't direct, confusion in consumers' mind about whose the product was. But again, the Court of Appeal refused to depart from that case of L'Oréal. And these are the reasons it gave, which again, very similar to previous cases. The relevant domestic provisions which implemented the EU law remained unchanged, and the courts should therefore strive for harmony with the Court of Justice and other European courts, unless the Court of Justice's interpretation was erroneous. If they had departed from the Court of Justice's case law, the Court of Appeal would have needed a different principled basis for determining what's an unfair advantage, and Aldi didn't offer them any support with what that different principled basis should be. Again, there's a point about whether there's an isolated decision or a body of case law. L'Oréal was not isolated and had been applied by the General Court and the Intellectual Property Office, and in that context, again, departure would cause considerable uncertainty. Finally, again, the Court of Justice's judgment in L'Oréal had not restricted the proper development of the law or turned it in a wrong direction, and it didn't prevent fair competition as opposed to unfair competition. So those are all cases really about the principles when the power to depart is available, of when the court, what the court will take into account when it's departing. But there's another very recent case on whether the court actually has the power to depart at all. And this is a case called Merck. It was a challenge to a refusal of an application for a supplementary protection certificate in the context of patent protection for pharmaceuticals. And Merck, in that case, asked the Court of Appeal to depart from a particular CJU case called Santon. The Court of Appeal held that it just didn't have the power to do so, and that power is set out in the rather long-winded named regulations, the European Union Withdrawal Act 2018 relevant court retained EU case law regulations. Those are the regulations which give the Court of Appeal the power to depart from previous EU case law and circumscribe that power. And what those regulations say is that where there is post-Brexit EU case law, which modifies or applies retained EU case law and is binding on a court, that court cannot depart from that retained EU case law. So in this case, there was a decision of the Court of Appeal post-Brexit applying EU case law, the case of Santon. And because there had been that previous Court of Appeal decision, that was binding on the Court of Appeal in Merck, and it just simply didn't have the power to depart from the case of Santon. Young v Bristol Aeroplane will be relevant here. So if the Court of Appeal has the power to depart from its own case law applying those factors, then it will be able to also depart from the retained EU case law. But in this case, it was held that none of those factors applied. The court also considered, as with the previous three cases, whether it would have departed from Santon if it had had the power to do so. And again, its answer was no, for much the same reasons as given in previous cases. And again, Lord Justice Arnold, although he wasn't the leading judge in this case, was involved and did give a short judgment. So just an overview of all those cases which I've just gone through. So first of all, you need to check, is there any relevant binding post-Brexit case law, so decisions of the Court of Appeal or the Supreme Court that modify or apply EU law? Because in that case, if you're asking the Court of Appeal to depart, they may not have the power to do so. If not, and if there is that power, the principles that the Court of Appeal and likely the Supreme Court will apply are, well, first of all, it's still a very high threshold. There can't just be disagreement with the other decision. There has to be something more. It will be harder to depart where there's a large body of case law or case law is based on an international treaty. On the other hand, it will be easier where there is a conflicting position in EU case law or different courts haven't followed various judgments. Legal certainty will be highly relevant, as well as any academic criticism, and the question of whether the particular EU law impedes or restricts the proper development of the law, again, will be crucial. Michael obviously explained that under Section 6 of the Rule Act, a slight lessening of the test is proposed to make it slightly easier to depart from retained EU case law. That's not yet implemented. I think we don't really know if this government will want to implement it in future. So really TBC what's going to happen on that. So now the status of post-Brexit CJEU case law. So everything I've said till now has been case law that was issued essentially before we left at the end of 2020. So what about decisions that are handed down after 2020? The legislation simply says the courts can take it or may take into account such case law. But in tune-in, the Court of Appeal indicated that in some circumstances, those decisions will be highly persuasive. And that is where, for example, a decision is one of many judgments, most of which are retained EU law because they all occurred before 2020, but this one in tune-in, there happened to be one after 2020. And when it's part of that body of case law, that post-Brexit case is also going to be very relevant. It'll be relevant where the cases build upon and further refine the CJEU's previous pre-Brexit jurisprudence. Decisions of the Grand Chamber are likely to be more persuasive than other decisions. Obviously, decisions which are directly relevant to the present case will be more persuasive. And in particular, in the tune-in case, this decision addressed the relationship between earlier Court of Justice decisions, which appeared to be conflicting. So it was helpful in resolving that tension. And I think we're going to be seeing more and more cases where parties appeal to post-Brexit case law on these kinds of principles because it supports their case. So obviously they'll want to refer to those cases. There was a warning from Rose LJ in this context, in the tune-in case, about essentially putting long summaries of what the state of the law is in Court of Appeal judgments. That shouldn't necessarily be taken as binding on lower courts because they still can have regard to subsequent CJEU case law and treat it as persuasive. So in a way here, Lady Justice Rose was saying, you should be looking at what the position is in the EU now, not just what it was pre-Brexit, and taking that into account where it's relevant. So then the legal status of EU rights arising to Brexit, and I'm sure many of you will be familiar with this claim which has gone through the courts as we've become more and more familiar with the Brexit legal framework. And this was essentially a compensation claim for a delayed flight due to a pilot being ill and whether that illness was extraordinary circumstances, meaning that compensation was not payable. It's a really detailed and complicated judgment, one which you kind of need a wet towel around your head to really get to grips with. And obviously I can't deal with all of the aspects in the next few moments. Many of those aspects will probably be more of academic than practical interest. But I want to highlight really the central finding here, which was about a debate in the courts and academia regarding two rival analyses of how the Liptons' accrued right, their cause of action for compensation, was protected following the UK's exit from the EU. And the two rival analyses were one, the complete code analysis, which essentially said that the EU Withdrawal Act 2018, the 2018 Act, as Michael introduced it, comprehensively deals with EU law. So all accrued EU law causes of action become part of retained or assimilated EU law. They don't have some kind of separate status outside the Withdrawal Act. And the other analysis, called the Interpretation Act analysis, essentially said that what the Withdrawal Act does is it only brings forward the status of the legislative instrument itself. So here, the regulation which granted the right to compensation, not the causes of action which were reliant on that regulation. Those causes of action are saved by the Interpretation Act 1978, Section 16, which provides that where an act repeals an enactment, the repeal does not, unless the contrary intention shows, affect any right, privilege, obligation or liability acquired, accrued or incurred under that enactment. So the Supreme Court found that the complete code analysis was correct, although Lord Lloyd-Jones did issue a dissent in reliance on the Interpretation Act analysis. And in fact, that question made no difference to the outcome, because both the majority and the minority agreed that being ill is not an exceptional circumstance, so compensation was payable. But although essentially this whole very large part of the judgment was overturned, given the detailed analysis, it is likely that the lower courts are going to apply, particularly the fact that it's a detailed analysis of the Supreme Court. So the reasoning for the majority was finding that the complete code analysis applied was based on Section 3(2)A of the Withdrawal Act 2018, essentially a factory interpretation point. So that said that EU regulations like this one with the compensation provision fall within the definition of direct EU legislation as they have effect in EU law immediately before Brexit on the 31st of December 2020. And that effect included causes of action that could be recognised and enforced by the domestic court, as well as the text of the legislation itself. So in a sense, the court here is applying the concept of direct effect, as Michael explained in Van Genden Loos. The direct effect is not just the text of the legislation itself, but also that cause of action that individuals had to have their compensation claims determined in English courts. And the reasoning of the Supreme Court in this case was that this complete code analysis aligns with the fundamental purpose of the Withdrawal Act, which is to provide comprehensively for post-Brexit legal landscape. And it was really signalling a break here with the past and a wholesale shift of all relevant legal regimes into a purely domestic framework. Whereas the Interpretation Act analysis would mean that a really extensive part of the new legal order, the ongoing domestic enforcement of pre-Brexit accrued causes of action, was not expressly covered by any regime at all. And in fact, what could have happened is that that would simply be covered by ordinary EU law still, so there'd be no power to depart from EU law and no power to take into account only subsequent EU decisions, but you'd actually have to just apply EU law completely as it was prior to Brexit. And the majority just thought that couldn't be right. So in this case, obviously it didn't make a difference, but if the court had been asked to depart from CJEU EU case law, it might well have led to a different outcome. So in future cases, this decision may well have a material impact. I just want to reference briefly the case of Skykick, which Michael mentioned, again, a very complicated case in the context of trademark law. And in there, a differently constituted Supreme Court adopted a slightly different approach by reference to specific provisions in the withdrawal agreement, which essentially maintained the EU law position. And the kind of interpretive approach they took is more aligned with the Interpretation Act analysis rather than the complete code analysis, but it was based on very specific provisions in the withdrawal agreement applying to trademarks. So it's not unlikely to be a general application. But I mean, interesting and perhaps encouraging to note on this very difficult topic, even the Supreme Court are struggling with this and having slightly different interpretations. So finally, I just want to briefly touch on conforming interpretation after Rule 2023. And given that this Act is only really coming into, or has only really come into effect in the last year, we haven't really seen any cases where it's actually applied to a legal situation that occurred after the end of 2023. But the courts have started to opine on how they would have decided the case had it been subject to the provisions of rule. And in particular, given the abolition of supremacy and the general principles of EU law, that the courts would no longer be obliged to interpret legislation, domestic legislation, consistently with directives that are implemented by that legislation. And e-accounting was again a trademark infringement case through the use of the sign resembling a trademark in Google keywords and internet advertising. And the judge there decided to give some guidance for future cases in which this issue might arise post-2023. And there the judge said that where domestic legislation was enacted to implement a directive, although you'd no longer be obliged to interpret it in conformity, the directive could be an external aid to interpretation under normal statutory interpretation rules and so lead to the same result. And similarly, in CG Fry, which was all about the obligation to carry out appropriate assessment under the habitats regulations, and whether that applied after planning permission had been granted at the reserved matters stage, the court said what you have to do is begin with domestic legislation as drafted and apply ordinary principle of statutory interpretation. And in that case, the sort of conforming interpretation principle resulted in the same outcome as the ordinary principles of statutory interpretation. So we can see here that there's quite a strong possibility that even without this conforming interpretation principle, we are going to see similar interpretations under ordinary statutory principles of construction. Just to note, the CG Fry case was appealed to the Supreme Court. That appeal was heard in February this year. So hopefully we'll have some further guidance from the Supreme Court on indirect effect and interpretation in due course. So I'll hand over to Merrow.
Brilliant. Well, I think you'll probably all agree with me that those were two very informative and somehow very efficient talks in covering all the ground that really we need to be aware of. And we've also been very efficient, and we have got a bit of time for questions. And I can see we've had, I think, 2 questions. I can see Hugh's asked a question and then said that actually Esther's managed to answer it just now. But if I can start with, I think it's Matt Gilks has got a question right at the top about proportionality. Hopefully, sorry, this is my competence in moving a computer screen from the speakers to see. But it's a very interesting question, I think, that will probably be plaguing a lot of us, about the extent to which a sort of general principle, like the principle of proportionality, that in its own way has legs domestically and also has influences from obviously the EU law roots. To what extent does that continue to have a life of its own, as he puts it, in the post-Brexit scenario? I don't know if either of you or whoever wants to.
Happy to give some initial thoughts on that.
That's a good question.
In terms of the application of general principles of EU law, once you fall within the scope of the 2023 Act, bearing in mind it doesn't have any retrospective force, going forwards, you would not apply a general principle of EU law because they cease to have effect domestically. And so if there's a general principle of proportionality, you would not apply it as a general principle of EU law. But Matt, as you rightly note in your question, there will be some interesting issues as to, well, I mean, do we have a domestic concept of proportionality? And, you know, that was discussed, I think, in some 1970s cases with Lord Denning, such as ex parte hook, the idea of a punishment having to be proportionate, and that was strictly as a matter of domestic law. Proportionality also is a very important part of the European Convention on Human Rights and the 1998 Human Rights Act as well. So I think the answer in terms of the application itself would be that you can't apply a general principle of EU law anymore because it's not part of domestic law. But that leads on to the question of, well, would we be able to find one domestically? That deals with sort of like the first part of the answer. The second part of the answer is that general principle of EU law, they aren't just relied on in terms of, you know, the application of a general principle itself. They can also be relied upon as sort of like a legislative backdrop that informs the interpretation of EU legislation. And I think now it would be clear that retained EU law needs to be interpreted by reference to domestic principles of interpretation alone. So again, you wouldn't have regard to that. But I think you're absolutely right in recognising that it's difficult after the UK was part of, you know, the EU legal order for 40 years, more than 40 years, trying to disentangle and see, well, actually, would we have come up with a homegrown form of proportionality in the absence of it? And unfortunately, we're now going to have to reconcile with a lot of those questions.
Yeah, I mean, I don't have very much to add to that. I'd just say I think proportionality is obviously very general, but if you think maybe in the more specific environmental context that we deal with a lot, the precautionary principle, I don't think the precautionary principle will be completely out of our case law as a result of these changes. I think it is still going to inform principles of interpretation. I think we will see that. And I think there will be development of the common law and kind of homegrown principles like that becoming more established rather than by reliance necessarily to how they're expressed in EU case law.
Brilliant. I think also raising the touching on those issues of legal certainty, I think trying to disentangle aspects like that, which are so wrapped up in different areas of our domestic law, will perhaps not be the best for legal certainty. So anyway, that's very interesting answer, so thank you. And the next question, as I say, is from Hugh Craddock, and I think it's directed for Michael, but either of you feel free to jump in on this. But as he says, I think it was touched on, Esther. I don't know if you've had a chance to look at it, but in your last...
Yeah, so I think, as I said, in e-accounting, it can be considered an external aid, and I think Hugh will be very familiar with the Darwell case that we did together. Obviously, you start with the natural and ordinary meaning of the words, and external aids won't always be relevant, particularly if the wording is not ambiguous. But the directives will have a role as external aids to some extent, particularly where there's ambiguity. So yes, I do think they will still have a role.
It's quite interesting in that, you know, when we say, you need to interpret UK law by reference to domestic principles. I mean, our domestic principles of interpretation are fairly flexible, and it would stand to reason that if something was passed to implement a directive, Parliament or the rule maker or whomever would have probably intended to ensure that the directive was fulfilled. And so it would make sense to have regard to the directive. It's just that the analysis in that case would be our domestic judges want to do that, and so therefore they are doing that. They're not doing it because they are told that they have to by virtue of a principle of EU supremacy. And so in some respects, you wonder how much difference it is going to make, given that our domestic principles of interpretation are, as I've said, relatively flexible.
There are quite a few pieces of legislation which implement directives, for example, the habitats regulations, which have specific obligations to comply with the directives. So I think in that case, where you've got specific legislation where the directive has essentially been implemented by saying comply with this article of the directive, it would be very odd not to then take into account the directive itself and the wording of the directive itself when you're interpreting it. So I think in those cases, the directive will have an even more important role where it's almost been incorporated by the wording of the domestic legislation.
I don't think I can add anything to these answers. This is great, but I think unless there are any other questions, but please do. We've still got quite high attendance, so please do if you do want. Oh, I've got another one. Again, I'm not the best with the technology. No, that's just a thank you from Hugh. Brilliant. Yes, if there aren't any other questions, then I think I will call us to a close, and you can go out and enjoy the last bit of sunshine before hitting the desk for the afternoon. So thank you all very much again for attending. Just a reminder again about that next webinar on the 4th of June. Yes, I hope you all have a lovely afternoon. Thank you very much to our two speakers. As I say, I think we all know what we need to know now. Or if there is another question, we might have to tackle it. No, brilliant. They're just thanks. So thank you. All the best.